Ownership is not a feeling, a favor, or a family consensus. It is a legal condition created by documentation, maintained by clarity, and protected by law. Yet many people misunderstand ownership precisely because it exists alongside relationships. When property sits inside families, homes passed down, houses shared for holidays, land connected to memory, people begin to confuse emotional proximity with legal authority. Shared history starts to feel like shared control. This is where conflict quietly begins, not with malice, but with assumption. The most important educational truth is this: no amount of sacrifice, care, or time spent near a property converts into ownership unless the law says so. Love does not transfer title. Obligation does not rewrite deeds. Longevity does not override documentation. Ownership remains intact even when emotions intensify, even when guilt is applied, even when pressure is framed as concern. The law does not measure affection, it measures proof. Family pressure often arrives disguised as practicality. Phrases like "it would be easier if," "we're just thinking ahead," or "at your age," "this might be too much," are not inherently malicious. But they function as soft coercion when they are used to bypass consent. The educational mistake many owners make is responding emotionally to these statements instead of structurally. Emotional responses invite debate. Structural responses end it. Clear titles are the foundation of ownership. A title establishes who owns a property, how it is owned, and what rights accompany it. If a title is unclear, outdated, or misunderstood, it creates a vacuum that others will attempt to fill with opinion. Joint tenancy, tenants in common, sole ownership. These are not interchangeable labels. Each carries specific rights and consequences. When families argue over property, they are rarely arguing about love, they are arguing over interpretations of paperwork they do not fully understand. Wills and trusts exist to prevent these interpretations from becoming conflicts. A will speaks after death, but its clarity, or lack of it, determines whether peace or litigation follows. A vague will invites assumptions. A detailed will removes them. Trusts, on the other hand, operate during life and after death, making them one of the most effective tools for maintaining control while reducing future disputes. They allow an owner to decide not only who benefits, but how, when, and under what conditions. This is not about mistrust, it is about foresight. Many people avoid formal planning because they fear it signals distrust toward family. In reality, planning is an act of respect. It respects relationships enough to protect them from ambiguity. It respects oneself enough to state intentions clearly, rather than leaving them to be negotiated under stress. Families fracture not because documents exist, but because they do not. Another critical misunderstanding is the belief that age diminishes authority. In law, age does not weaken ownership, incapacity does, and incapacity must be proven, not presumed. Suggesting that someone should relinquish control for safety or for simplicity without legal findings is not protective. It is intrusive. This is why durable powers of attorney, healthcare directives, and capacity safeguards matter. They draw a line between assistance and takeover. When ownership is challenged, the calmest response is not explanation, but reference. Refer to the deed, refer to the trust, refer to counsel. This shifts the conversation from emotion to fact. It also prevents escalation, because facts do not argue, they stand. People often believe that asserting ownership will damage relationships, but the opposite is often true. Unclear boundaries breed resentment. Clear ones create predictability, even if they disappoint. There is also an educational lesson in silence. Silence can be dignified when it is strategic, but dangerous when it is avoidance. Failing to clarify ownership early allows others to fill in the blanks. Over time, those assumptions harden into expectations, and expectations, when unmet, feel like betrayal. Speaking early, through documentation rather than confrontation, prevents this cycle. Ownership being a legal right rather than a family vote does not mean family is irrelevant. It means family roles must exist within lawful limits. Help can be accepted without surrendering control. Input can be heard without being binding. Proximity does not equal permission. These distinctions preserve both property and relationships. Ultimately, the law exists to protect individuals from precisely this kind of pressure, the kind that feels personal, emotional, and morally charged. It provides neutral ground when feelings become unreliable. Understanding this is empowering. It allows owners to act without guilt, to say no without hostility, and to remain generous without becoming vulnerable. The educational takeaway is simple but profound. If ownership matters, document it. If peace matters, clarify it. And if dignity matters, remember that your rights are not something others get to vote on, no matter how close they are to you. Boundaries are often misunderstood as moments of confrontation, raised voices, emotional speeches, decisive ultimatums. In reality, the most effective boundaries are rarely dramatic. They are quiet, pre-existing, and already in place long before they are tested. True authority does not announce itself in anger. It reveals itself through preparation. When boundaries are built into systems, documents, and procedures, they do not need defending in the heat of conflict. They simply function. Many people delay setting boundaries because they associate them with discomfort. They fear being seen as difficult, ungrateful, or unkind. As a result, they wait until pressure becomes unbearable and then attempt to establish limits through confrontation. This is where boundaries fail most often. Confrontation invites negotiation. Negotiation invites persuasion. Persuasion erodes clarity. Preparation, by contrast, removes the debate entirely. Calm authority is not a personality trait. It is an outcome of foresight. It comes from knowing that decisions have already been made, documented, and protected. When someone asks for access, control, or influence that crosses a line, the prepared individual does not need to argue. They can refer. They can rest on structure. The conversation shifts from personal refusal to procedural reality. Documentation is one of the most underestimated tools of boundary enforcement. Written decisions transform intentions into facts. A living trust, a power of attorney with defined limits, a clearly drafted will, a lease agreement, or even a simple written policy can do what hours of emotional explanation cannot. Documents are not emotional. They do not change tone. They do not soften under pressure. That consistency is precisely what gives them power. Foresight means anticipating where pressure might arise and addressing it before it does. This is not pessimism, it is responsibility. Families, partnerships, and communities all experience moments where interests diverge. Assuming harmony will always prevail is not optimism, it is risk. Prepared boundaries acknowledge reality without cynicism. They say, if this situation ever occurs, here is how it will be handled, removing the need for reactive decisions under stress. One of the most important educational insights is that boundaries supported by structure protect relationships rather than damage them. When limits are clear, people know where they stand. Ambiguity creates hope, and hope creates entitlement. When expectations are left undefined, disappointment feels personal. Clear boundaries prevent this by setting expectations early and impersonally. Confrontation often escalates because it centers on character. Statements like "you're being unfair" or "you don't trust me" shift the discussion away from behavior and toward identity. Preparation avoids this trap. A boundary expressed through documentation is not a judgment, it is a policy. It does not accuse, it defines. Another advantage of preparation is emotional regulation. When boundaries are already in place, the person enforcing them does not need to summon courage in the moment. They are not improvising. This reduces anxiety and prevents reactive language that can be used against them later. Calmness in this sense is not emotional detachment. It is the absence of urgency. Legal structures are especially powerful because they externalize the boundary. The boundary is no longer what I want versus what you want. It becomes what is allowed versus what is not. This shift removes the personal struggle for dominance and replaces it with neutral standards. It also protects against manipulation, guilt, and moral pressure. which often succeed precisely because they target emotions rather than facts. Prepared boundaries also scale over time. A confrontation resolves one moment, preparation governs many. A single conversation might stop one request, but a documented structure prevents the next 10. This is why professionals, institutions, and systems rely on policies rather than case-by-case arguments. Individuals benefit from the same approach in their personal lives. There is also an educational lesson in consistency. Boundaries enforced through preparation are applied uniformly. They do not change depending on mood, relationship, or circumstance. This consistency builds credibility. People may not like the boundary, but they learn that it does not bend under pressure. Over time, this reduces attempts to cross it. Many people worry that preparing boundaries signals mistrust. In truth, it signals self-respect. It acknowledges that clarity is kinder than confusion and that structure prevents resentment. Trust thrives in environments where roles and limits are understood. Preparation provides that understanding. Importantly, preparation does not eliminate compassion. One can be empathetic while remaining firm. One can listen without yielding. Boundaries are not walls, they are frames. They define where connection happens safely. Without them, relationships collapse under unspoken expectations and repeated violations. The ultimate educational takeaway is that authority is not claimed in the moment of conflict. It is established beforehand. When boundaries are thoughtfully designed and properly documented, they stand on their own. No raised voice is required. No argument is necessary. The boundary speaks quietly, and because it is prepared, it is heard. Silence is often mistaken for peace. In reality, silence frequently creates a vacuum, one that uncertainty, assumption, and pressure quickly fill. When important decisions are delayed, unspoken, or left to work themselves out, the absence of clarity becomes a risk factor. This is especially true in matters involving property, authority, finances, or future planning. Without professional guidance, people rely on informal understandings, emotional promises, and shifting expectations, none of which hold up when interests collide. Delaying counsel does not freeze a situation in place, it allows it to evolve without structure. While one person waits to feel ready, others move forward with their own interpretations. Silence gives those interpretations room to grow. Over time, they harden into expectations, and expectations, when unmet, turn into pressure. What began as ambiguity becomes leverage. Many people avoid seeking professional advice because they fear it will escalate conflict or make situations feel too serious. This avoidance is educationally significant. It reflects a belief that clarity causes tension, when in fact, ambiguity does. Counsel does not create disputes. It reveals where reality already stands. It replaces guesswork with fact, speculation with law, and emotion with process. Early legal guidance transforms uncertainty into strategy. Instead of reacting to requests, demands, or insinuations, the advised individual operates from a position of knowledge. They understand their rights, their obligations, and their options. This understanding changes behavior. It replaces hesitation with composure and defensiveness with calm explanation. Strategy does not mean aggression. It means intention. One of the greatest risks of silence is coercion disguised as concern. Without counsel, people may not recognize when influence crosses into pressure. Statements framed as advice. This is for your own good. You don't need to worry about this anymore. We'll handle it. Can slowly erode autonomy if not checked by informed boundaries. Counsel provides the language and structure to identify these moments and respond appropriately. Professional advice also acts as a buffer. It removes the burden of interpretation from personal relationships. Instead of one person deciding what is fair, lawful standards guide the outcome. This protects dignity on all sides. Saying this is how it must be handled is very different from saying this is what I want. The former invites respect, the latter invites argument. Silence often stems from discomfort with complexity. Legal matters can feel intimidating, and many assume they should wait until a crisis occurs before consulting a professional. This is a costly misconception. By the time conflict surfaces, options are narrower, and emotions are higher. Early counsel expands choices. It allows for planning rather than damage control. There is also a critical educational distinction between secrecy and privacy. Seeking counsel is not an act of secrecy, it is an act of responsibility. Privacy protects decision-making while it is still forming. Silence, by contrast, leaves decisions unformed and vulnerable. Counsel helps articulate intentions clearly so they can be communicated when appropriate without confusion or apology. Clarity safeguards dignity because it prevents people from being cornered into explanations they are not prepared to give. When someone knows their position, they do not need to justify it repeatedly. They can state it once, calmly and consistently. This consistency discourages manipulation and reduces emotional wear. Another overlooked benefit of early counsel is prevention. Many disputes never arise because expectations are set before they are tested, documents are updated, roles are defined, authority is allocated. This proactive approach does not eliminate disagreement, but it prevents misunderstanding from becoming conflict. Silence also carries legal consequences. In some contexts, inaction can be interpreted as consent. Verbal agreements, informal arrangements, or prolonged acquiescence can weaken later claims. Counsel educates individuals on when silence is neutral and when it is dangerous. Knowing this distinction is empowering. Ultimately, clarity is not about control, it is about agency. It ensures that decisions reflect intention rather than pressure. Counsel supports this by providing a framework in which choices are informed, deliberate, and protected. Dignity is preserved not by avoiding difficult conversations, but by entering them equipped with knowledge. The educational takeaway is clear. Waiting feels safe, but it is not. Silence invites others to define the narrative. Counsel allows individuals to define it themselves. By seeking guidance early, uncertainty becomes strategy, vulnerability becomes preparedness, and dignity remains intact. Age is often treated as a quiet subtraction. Society speaks about growing older as though capacity steadily drains away, as though authority naturally transfers from the individual to those around them simply because time has passed. This assumption is not only inaccurate, it is dangerous. Age does not reduce agency. In many respects, it refines it. What changes with time is not the right to decide, but the clarity with which decisions can be made. Agency is the ability to author one's own life. It includes choice, consent, and control. None of these expire with age. What often does change is how others perceive them. Well-intentioned concern can slide into overreach. Familiarity can blur respect. People begin to speak about older individuals rather than with them. This shift is subtle, but its impact is profound. When agency is assumed to be diminished, it is more easily bypassed. Wisdom accumulates because experience accumulates. Years lived translate into pattern recognition, emotional regulation, and long-term thinking. Older adults often possess a deeper understanding of consequences because they have witnessed them unfold. This makes decision-making not weaker, but more deliberate. Slower decisions are frequently mistaken for indecision, when in reality they reflect discernment. One of the most persistent myths is that aging requires surrendering control for safety or simplicity. While support can be appropriate, it must never be imposed without consent and legal justification. Assistance and authority are not the same. Accepting help does not require relinquishing agency. The educational failure occurs when these concepts are collapsed into one, allowing others to step beyond support into governance. The law recognizes this distinction clearly. Capacity is not determined by age, but by demonstrated ability to understand and decide. Until incapacity is legally established, agency remains intact. This legal standard exists precisely to prevent assumptions from becoming takeovers. Understanding this empowers older individuals to resist premature or unnecessary control. Another overlooked aspect of aging is the strengthening of values. With time, priorities sharpen. What matters becomes clearer, not fuzzier. This clarity enhances agency because decisions align more closely with long-held principles. Younger years may involve experimentation and uncertainty. Later years often bring coherence. Decisions made from coherence carry weight. Social narratives often pressure older individuals to defer, to avoid being a burden, or to keep the peace. These pressures can lead to self-silencing. Silence, however, should never be confused with consent. Choosing not to speak may preserve harmony temporarily, but it erodes autonomy over time. Agency requires expression, not apology. Reframing aging as a period of heightened decision-making power also means recognizing the strategic advantage of foresight. Older adults are uniquely positioned to plan effectively because they understand both the past and the future implications of their choices. Planning is not a sign of decline, it is an assertion of control. It says, "I am deciding now while my voice is clear." There is also dignity in consistency. When older individuals assert their decisions calmly and repeatedly, they reinforce their authority. Authority does not need to be loud to be effective. It needs to be steady. Consistency teaches others how to engage respectfully. Importantly, agency does not mean isolation. Interdependence is not weakness. The educational distinction lies in who retains final say. Collaboration honors agency, substitution erases it. Healthy support structures amplify decision-making rather than replace it. The greatest risk to agency in later life is not age itself, but the internalization of diminished expectations. When individuals begin to believe they should step back simply because they are older, they participate in their own erasure. Reclaiming agency starts with rejecting that narrative. Ultimately, aging is not a withdrawal from authorship, it is an opportunity to write with intention. Wisdom is not passive, it is an active resource that guides choices with precision. Recognizing this transforms aging from a period of loss into one of authority. The educational takeaway is clear: agency endures. Age adds perspective, not permission for others to decide. When this truth is understood and asserted, older individuals do not lose control. They model what informed, deliberate power truly looks like.